Hey, welcome to The Explainer. Today we're going to tackle something that can be a real headache for a lot of people: legal research. We're going to break it all down into a clear visual guide that you can actually use.
Yeah, if you have, you are definitely not alone. It's that feeling of staring at a mountain of information with no idea where to start. But don't you worry. Today, we're charting a course right through that legal labyrinth with a really solid, systematic approach that's going to turn all that confusion into clarity.
So, here's our game plan. We'll start by talking about the challenge itself. Then, I'll introduce you to a really powerful framework to guide you. After that, we'll sharpen our research strategy, cover a super important quality check, and finally, we'll look at the ultimate goal of all this work.
All right, let's dive right in. First things first, let's get a handle on why legal research can feel so overwhelming in the first place.
Okay, so here's the deal. The massive body of law built from past court decisions, what we call the common law, isn't always neat and tidy. You know, it's not like a perfectly organized library. It can be sprawling, super complex, and sometimes even contradictory. And that's what makes it so hard to find exactly what you're looking for.
But what if I told you there's a map for this maze? Well, there is. It's a powerful 5-step process known as the FILAC framework, and it's specifically designed to bring some serious order to all that chaos. FILAC. It's an acronym, and it stands for Facts, Issues, Law, Analysis, and Conclusions. The beauty of this is that it stops you from just searching randomly and instead gets you to conduct a really thorough, systematic investigation of any legal problem you're up against.
Everything starts right here. Before you even think about looking up a single law, you have to nail down the who, what, where, when, and why of your situation. These facts, they are the absolute foundation that your entire case is built on.
Next up, you take those facts and you use them to frame very specific legal questions. What are the core points of conflict? What are the uncertainties that the law needs to address? Those are your issues.
Now we get to the L for law, and this is the heart of the research phase. With your issues clearly defined, now you can go hunting for the specific statutes and court decisions that apply. And stick with me, because we're going to talk a lot more about the best way to do this in just a moment.
Now, this is where you connect the dots. You take the abstract law you found and you apply it directly to the concrete facts of your situation. How does this precedent or that statute actually impact your specific case? Well, that's analysis. And finally, based on all that rigorous analysis, you can develop a well-reasoned conclusion. And look, this isn't just a guess. It's a defensible answer to the legal question you started with, and it's backed by solid research.
So now that we have the framework, let's talk strategy. Specifically, what's the most effective way to tackle that L for law step we just talked about? Because there's a right way, and then there's the hard way.
Pretty much every expert out there agrees on this crucial strategy. Don't just jump straight into the deep end by reading dense statutes and cases first. You've got to start broad.
And this is the key distinction to get your head around. Secondary sources are expert commentaries about the law. They explain it, they analyze it. Think textbooks or law journal articles. Primary sources, on the other hand, are the law itself, the actual words of a statute or a judicial decision.
So why on earth would you start with the commentary? Well, it's a brilliant move. These secondary sources give you a fantastic overview. They're written by specialists who've already done the heavy lifting, and, this is the best part, they point you directly to the most important cases and statutes. It saves you an incredible amount of time.
Okay, so once you've used those secondary sources and found a key case, there's one final, absolutely non-negotiable step. This is the quality check that really separates the amateurs from the professionals. It's called noting up.
Simply put, you have to make sure the case you're about to rely on is still valid. Has it been overturned? Has a more recent court criticized it? Noting up is how you answer these critical questions.
And you do this by checking two things. First, its judicial history. Was the decision appealed and then upheld or reversed? And second, its judicial treatment. What have later judges said about this case? This whole process ensures your legal foundation is solid as a rock.
So we have our framework, our strategy, and our quality check. All of this builds to the ultimate purpose of legal research, because it is not just about collecting information.
And there it is. The real goal is prediction. You synthesize everything you found, the facts, the issues, the law, the analysis, to make an educated forecast of how a court would most likely rule. That right there is the power of this process.
By following this systematic process, using FILAC to structure your thinking, starting broad with secondary sources, and always verifying your work by noting up. Legal research transforms from an overwhelming task into a powerful problem-solving skill. So the only question left is, what problem will you solve first?